Top questions executors ask about real estate in Georgia probate. Let's talk about that. My name is Tonya Byrd and I am a probate real estate specialist here in the state of Georgia. I am part of a husband and wife team called the Byrd Group, and we are brokered by Keller Williams Realty Atlanta Partners here in the greater Atlanta area. And we deal with a lot of questions that we get when people are getting ready to go through the probate process and they just don't know what to do about the house. So let's dive into those questions today so we can answer them for you right here. Can I sell the house before the probate is complete? Well, probate is a period of time from which you petition the court to be the executor all the way until you've settled all the debt, you have taken in all of the various assets. Maybe you sell the house and that money goes into a bank account. When all that stuff is said and done, you filed a tax report and you've settled everything and the court says we can close this out. That can take anywhere from 9 to 18 months, depending on how complicated the estate is or whether or not people are getting along. What the key is here is whether or not you have the paperwork that gives you the permission to sell the house. You are looking to get those letters of testamentary if there was a will, letters of administration if there was not. Once you have those letters in hand, you can act on behalf of the estate. Now, the only other thing that could slow the process of selling the house is if you did not get the leave to sell waived. If that wasn't waived in your paperwork, you can still sign a listing agreement. Once you get a contract, you just have to petition the court again to show the contract to get the permission to sell the house. And that can drag things out longer. So having that waived can make it go faster. Now, how fast has I've seen this go to get the letters back? If you're in a county that moves fast. So I have seen it move as fast as 6 weeks from the time they petition it, taking their oath, everybody's getting along and they're signing the things and they're getting the things turned in. The newspaper ads run saying that they are going to be the executor of this estate. Nobody objects. I've seen that go as fast as 6 weeks. In other counties, they can be a little bit slower. I've seen it go 3 months. It helps if you have a will. It really does. And that is like your first safeguard when it comes to probate, is to have a will in place. Because otherwise, state law rules the day if there's no will. And sometimes that can slow down the probate process because the people who are trying to get permission to be the administrator want to make sure all the heirs agree and that everything is being done appropriately because the loved one didn't leave behind their wishes via a will. Do I need court approval before I can sell the house? Again, it all depends on paperwork, whether or not the leave to sell is waived. If it's waived and all the heirs agree, or the will says that it's waived, and you've got an initial in there saying it's waived, you don't have to get court permission to sell. You can sign on behalf of the estate and get the house sold. If it's not waived because maybe somebody's not cooperating, maybe an heir didn't sign some paperwork, then the court or the judge may not waive that. You may actually get your letters of administration, or if the will didn't give you permission to waive the leave of sale, then yes, that's where you have to go in front of the court to get that petition done. It has to be under contract for this to happen. And then once the petition is received, there's a 30-day wait window for anybody to object to the contract, the sales price, the terms of the sale. If somebody objects, of course, the process is going to be drag out longer. If they do object, the next step would be for everybody to have mediation. The two parties who are in disagreement would meet up with the attorneys and mediator and try to work things out. If that doesn't work out, then you would finally get a hearing in front of the judge for the judge to ultimately decide. That's why I always say things move so much quicker if everybody cooperates and if everybody gets everything signed in a timely fashion. Who pays for the mortgage, taxes, and insurance during the probate process? Well, if you have access to the money of the loved one who passed away, You can use that money to pay on the mortgage, the taxes, and the insurance. If they're out of money, then it can come out of your pocket. And then once the house sells, then the estate would reimburse you. Most people are sitting on a lot of equity in the home. Maybe there's a low mortgage, or maybe even the mortgage is paid off. Either way, there's a lot of equity, and the only way to access that is through selling the house. So as an executor or administrator, if you don't have the funds from the estate to pay for it, you can pay for it and get reimbursed. You have to, in the state of Georgia, keep up with the mortgage payments, because this is a non-judicial state, meaning that they don't have to take you in front of a judge to get foreclosed upon. And the probate process, unless the attorney petitions the court to stop a foreclosure, the probate process does not stop a foreclosure. As far as the taxes, the insurance, property taxes have to be paid too, because the county can foreclose upon you if you're not paying your property taxes. And you want it to be insured, because God forbid something happened to the house, it burned down, or somebody breaks in, stuff gets stolen. You need that insurance policy there to protect that asset for the estate. What if there's multiple heirs that they just don't agree? I run into this often. I think there's a statistic out there that says 70% of people fight over real estate after their loved one dies. And that's a sad, sad statistic, that only 30% of people are cooperating and moving along to make sure the probate process goes faster. Well, let's break it down, having a will versus not having a will. When you have a will, it should name an executor, and the heirs still have to be notified. Even if somebody who is an heir is written out of the will, they still have to be notified. With the will, somebody can object against that will and stop the whole probate process, so that can drag things on. But at the very least, at least you have that person's final wishes of what's supposed to happen with the estate via written form. Things can go a little bit easier with that piece of paper in hand, and it has to be an original. You cannot bring a copy into probate. It has to be the original will. If there is no will and you don't have people cooperating, and you're trying to be an administrator of the estate, then you may eventually get those letters of administration so you can act on behalf of the state, but the leave of sale might not be waived, as we discussed earlier. You may have to do an inventory of all the personal items and turn that into the court. You may have to go in and do an accounting of all the money. What is the house worth? That kind of asset thing, and report that back to the court. You may have to go out and get a bond and pay for it as like a mini insurance policy that protects the heirs. So if you as an administrator goes rogue and spends all the money, then they are protected through that bond. All of those things in Georgia can be waived and can make the process go faster. But if people aren't getting along, I have seen time and time again where people have their letters of administration, but those things aren't waived, and the administrator has to jump through extra hoops to get the information over to the court before things can get sold, before things can get into the estate account and settled, and everybody gets distributed their share of the estate. Do I need a special real estate agent to help me through probate? Do you really need an agent who specializes in probate? No. Will you want one? Yes. Somebody who has gone and taken the time, such as me and my husband, to go out and learn the probate law, the probate process, get with the vendors who can help you around getting the house ready to sell, helping you disperse of all the personal treasures, either to family members, or maybe you're donating them. Maybe some things are obsolete and they just have to be thrown away. Maybe you want to do an estate sale, those sort of things. You're going to want a real estate agent who understands the deadlines, can talk the talk to the attorneys, who can appropriately market the home, particularly if the leave of sale is not waived. Then we need to prepare a buyer as they come along that the process could get drugged out because we're waiting on the probate court to respond. So you're going to want somebody who can go out and read the documents and understand where you are in the process, know whether or not you got your letters of administration or your letters of testamentary, know to even ask for those sort of things, know that you have to have an EIN number set up, a state social security number called an EIN number, know that you have to have a special bank account set up for the estate and that all the funds go in there. An agent who hasn't gone through those special training unfortunately doesn't know those things. So if you need help finding an agent in your neck of the woods who specializes in probate, I will go the extra mile and make sure you get hooked up with somebody like that, so that it's not an extra bump in the road that you have to overcome because the real estate agent didn't know. After all, it's hard enough as it is maintaining the estate and trying to disperse of all the treasures to not have an extra headache on top of it because your agent didn't know some of these things. Should we sell it as is or should we fix it up first? That is going to be on you, whether or not you have time, energy, money to do those sort of things. I run into people who aren't in the same state trying to do probate, and it's really hard for them to manage a job of getting things updated or fixed up. So they want to sell it as is. I've run into people who have no money to do it. There's no money in the estate. There's no money in their accounts. And they are really desperate to get the house sold as quick as possible. So they'll want to sell it as is. This is one of those case-by-case basis where you really need to sit down with a real estate agent who understands this and weigh out all your options. What if you do sell it as is? What's that price look like? What is the expectations around selling it as is? What's the buyer pool for selling it as is? Are you going to run into a lot of investors? Maybe some fixer-upper kind of people who like to do DIY. Those are the kind of buyer pool versus going to the buyer pool that could open more doors, expose the house to more things because you were able to fix it up. Maybe a first-time home buyer, maybe somebody who's downsizing. So it opens up your buyer pool if you can fix it up. And some people don't have that option. It's a case-by-case basis. So feel free to reach out. I'm happy to talk people through what that looks like. Are there capital gains or other taxes involved during the probate process? There's definitely going to be a tax return filed. As I mentioned earlier, you got to create that EIN number, and the federal government's going to want you to file a tax return on the estate. So that is one thing that you'll have to do. Now, whether or not the estate owes taxes, that's where you need to go see a CPA. Obviously, I'm not a CPA. As far as capital gains go, that's all about where your basis is. The basis is what it cost when you bought the home. And if you have a husband and wife situation and one spouse passed away, in Georgia, you only get half step up on basis. So the wife would keep the original value of what you bought the house for, and 50% of the house would come up to the value on the day that that person died. And then you would add those two numbers together and you would have a new cost basis. If it's a single person that died, like let's say mom is single and she passes away and she's handing down the property to her children, you would get full step up in basis in that instance because mom's one person who owns the house outright. And it's the date of death value that you're standing at. Okay, so let's put a little scenario here. Let's say mom dies and the house is worth $250,000 in 2005. Let's say that you sit on it for 10 years and it appreciates at a very high level, and then you go to sell it. It's not your primary home. You're gonna pay capital gains tax because it's not your primary home. It would be date of death at $250,000. And then let's say it's $400,000 now. You're going to subtract out what it costs to sell the property from closing costs to what it costs to pay the compensation on the real estate agents. So what you net minus what the value was when it stepped up. That amount of money is on the hook for capital gains. Depending on where you are in the tax bracket for federal, it's 15 to 20% of that. For Georgia, it's 5.75%. also on, that's like the max. It's also on a scale. So if you sell it within the first year after someone dies, the likelihood of you having capital gains is slim because you're not going to have that growth. People may decide to hold on to it though, and if they do and it's investment property and you get ready to sell it, then that's where you need to explore your options. Maybe you want to sell it and put it into a different property, doing a 1031 exchange. There's other options you could do with it to try to avoid those taxes, but that's where you can reach out with somebody like me who understands these things and go through those options as well. Keep in mind, I'm not a CPA. I will always direct you to a CPA, but we can definitely look at some rough numbers. What happens to the proceeds of the sale? I have heard horror stories where people thought that the house would sell and everybody walk out with a check equally divided, and that's not how that works. Once the proceeds from the house will go into a special bank account that you set up for the estate attached to that EIN number, because once you get all the assets into that account, you need to make sure that all the debt that the estate may owe gets paid off as well before you can close out the estate and get the probate completely done. The proceeds go into the estate account until it's time to distribute what's in the estate account to the heirs and close out probate. How long does the process take for probate in the state of Georgia? I can give you rough timelines if everybody's getting along and this estate is easy, maybe 9 months. If it's more complicated or people aren't getting along, maybe 18 months. I mean, I'm working with a lady right now, I think, who opened something up in 2022 and we're still going on the probate. In that instance, people weren't getting along. I've seen probate get unnecessarily drug out over a year, over a clock, because somebody objected to the person who was petitioning the will. I've seen all kinds of crazy things where it gets dragged out. So it depends on how complicated is the estate and are people getting along. Again, once you have your letters of administration or your letters of testamentary, then we can relatively get the house on the market pretty quick. We'll do an analysis of what's happening in the market. We'll see what days on market are so we can navigate the expectations of when we should expect an offer. And then depending on the kind of buyer, whether they're cash or have a financing attached to it, how long that can take through the process of getting the house sold. All of those things are going to be different depending on what's happening in the market, the location, those sort of things. So getting with a real estate agent who can help you navigate those market numbers are key. Can I live at the property while it's going through probate? I'm going to say this is an attorney question. I've had people, well, I mean, like if you're married, let's say you're married and your spouse dies. Obviously, you're probating that side of the estate. You're going to be living in the house because your spouse died and it's still part of your property. If you don't own the property and you're trying to live in the property, I would really ask an attorney, particularly if people aren't getting along, they may not trust you. It could be an iffy situation. Now, have I had people stay overnight in a house that's going through probate because maybe they're out of town and they just need a place to stay while maybe they're working on the house? There's a fine line there, but I would send you back to the attorney to make sure that depending on your situation, it was okay to live on the property while it's going through the probate process. Every case is unique. That's why I'd always send it back to the attorney so you can get the best advice. So if you are handling probate in the state of Georgia, I can definitely help you in the greater Atlanta area. I can also get you connected if it's an area I can't service, it's in Georgia, with a real estate professional who specializes in probate. It's easy for me to go out there and find who those people are, connect you to make sure that you are taken care of. If you're in other parts of the country and need to be connected, I can connect you as well. I hope you found this information helpful. I hope that your probate process is going smooth. And watch this next video that we've done on probate so you can learn more, and I will see y'all later. Bye.